And welcome to the live virtual revisionary classes of Board of Studies ICAI. This is CA intermediate course and we are discussing the paper 2 on corporate and other laws. And specific topic which we will be discussing is the chapter on prospectus and allotment of securities. If you would recollect this particular topic, we covered in about 3 to 4 sessions in quite detail. And today's session is meant for a recap and probably answering all your questions. If you have any doubts, clarifications, I would be addressing that today in the session. Uh, I would encourage more number of questions, so you can use your chat box, put your questions and doubts and clarification, though we move ahead with a structured way of going through different sections, but you can ask any questions. I will accordingly, maneuver it and give you the responses. If you look at the previous year questions or previous year question papers, you will find that invariably there is some question with reference to this topic, and it's a very important topic as it covers prospectus, it covers your different types of prospectus, and you see how the procedure is there for issue of prospectus and the related concepts. And you also know about the civil and criminal liability of misstatement in the prospectus and what are the punishments around it. And then you understand the procedure for allotment of securities by the companies and ultimately the procedure of private placement of securities. So this is a very important topic as far as company law is concerned, because a lot of work goes at the back of it, probably what should be the contents of the prospectus, how the prospectus should be drafted, what are the major points which should be considered while drafting the prospectus, what is the objective of having that prospectus, different types of prospectus. These are the things which you should be aware of. And generically, the philosophy of raising and maintenance of capital should be clear to you. So if you are thorough with this particular thought, you would be in a situation to answer the questions with reference to this topic, that is prospectus and allotment of securities. So if we look at the chapter overview, you will find that this whole chapter is into two parts. Part one is the major part, that is section 23 to 41, which includes the prospectus and allotment of securities. And this deals specifically with issue of prospectus and related matters. So I have seen that the questions which have come up in the previous years is, mostly like a problem, or there is a situation given, and on the basis of the situation, there are some questions which are asked if you look at the previous year question papers. I'm sure you must have gone through them. And I was also going through the examiner notes. I think it is publicly available on your, Board of Studies website. And I would suggest you please go through those examiner notes also. It is very good resource because I was looking at it and it has provided the average examinee's response to the questions. So I think this is a very important input because generally we don't get this feedback. And I was quite happy to see that those feedbacks are candidly given, that students are answering generically or they are not very specific. So I think these comments are very important because when you are answering questions for a competitive examination, you should be looking into the head of the examiner, what he is thinking, what is the expectation of the examiner from the questions. So if you look at from the perspective, you will find that which sections are important, which topics are important, wherein the questions can be framed and questions can come up. If you see section 39 talks about allotment of securities, and the third part of this particular section of this particular part is on penalties. So there are heavy penalties, severe penalties for misstatement in the prospectus, including a criminal liability. So we will this is what is talked about in part one, that is public offer, wherein you are going to public for raising the capital. And then there is private placement. So private placement is a situation where you are reaching out to private people for raising the money. And this is called private placement. And we will talk about that private placement also. And these provisions are supplemented with the rules. So the Companies Act, Prospectus and Allotment of Securities Rules 2014 are also referred to in your course material. So on and off, you have to refer to this, and probably when you are answering, you should mention these rules also wherever applicable. Then your answer would be comprehensive, and your understanding about the topic will be shown as comprehensive. So this is the chapter overview, and this is how you need to, have the sense of the chapter when you are answering this particular question. So first, my idea would be that if you get a question, you need to first locate where your question lies. Where is the essence of the question? Whether it is focusing on penalties, whether it is focusing on allotment of securities, or it is talking about issue of prospectus. It may also happen that you have a single problem, and in the problem, all these three are covered. So it may also happen. In fact, all four are covered. So you have to accordingly answer the questions and then get marks out of it. Coming to the section-wise bifurcation, if you look at the chapter, this is chapter 3 of the Companies Act, that is prospectus and allotment of securities. And in there, you can see part 1 talks about public offer and part 2 talks about private placement. So in the public offer, if you look at the public offer part, you will see it begins with public offer and private placement. And from there, it flows power of Securities and Exchange Board to regulate issue and transfer of securities. Then it says document containing offer of securities for sale. Then matter to be stated in the prospectus, variation in terms of the contract, offer of sale, public offer of securities. Then advertisement of prospectus, how advertisement should happen. And then it is talking about different types of prospectus like shelf prospectus, red herring prospectus, and how the application forms has to be issued for securities, that is also mentioned. And then we move on to the liabilities part of it. And at this stage, criminal liability, civil liability, and then punishment for fraudulently inducing persons to invest money. And then action by affected persons, punishment for personation of accusation, a lot. And then after this, dealing with these penalties, then again, how the allotment of securities will happen, securities, how it will be dealt with at a stock exchange. And then one topic which is related is global depository receipt. So it is talking about international, issue of securities. And then ultimately the section 42 talks about the private placement. So this is how the sections are arranged in the Companies Act. And if you are referring to the company law, you will be in a situation to, go through these sections. I always advise my students that please go through the original section at least once, read it, because it gives you a sense of belongingness to the section. And whenever a question comes up, you will be in a better position to answer it technically, because it will not be a generic and vague answer. One of the most important examiner comments which I have read is that the answers are vague, answers are very generic, like you have tried to explain in a generic way. But since we are professionals, you will be going to become professionals as chartered accountants. So it is expected that your language is a bit technical as well, because you need to, show your professionalism through the language by putting across some technical terms which are used in the section. So it will not come automatically. It comes by way of a practice. So my advice would be that on each of these sections, do practice writing their main contents, writing their main ingredients of the section. This will help you prepare better, and you will be in a situation to answer the questions in a more technical and more mature way. Moving with the sections, we will now take up each of these, points one by one. And I would also expect your questions in the chat box so that we can discuss. So I will just give you a brief background of philosophy. This we have already discussed before, but let us look at it, that why we are placing so much of importance on this particular section. So there is a concept of raising and maintenance of capital, and it clearly says that whatever capital you are raising, you need to maintain just spend it on your own whims and fancies because and that is what is a guarded uh, regulation under the Companies Act, wherein you are trying to hold the finances which you have raised, because you cannot just leave the finances at the hands of the owners of the company and let them do whatever they want. That cannot be done, right? So you need to have some checks and balances, because otherwise they will be, wasting the money which they will be raising from public. And specifically when the money is raised from the public, these issues or these points need to be considered very, very carefully. So a company must preserve its capital and cannot return to its shareholders except in legally permitted ways. And this is also a baseline for corporate governance, because ultimately, if you look at it, shareholders are the owners of the company, but the management has to ensure that shareholders don't take away everything whatever they want. There is a mechanism by which they can take the profits out of the company by way of dividends or other mechanisms, but they cannot just dictate that, okay, fine, this year you give me this much of dividend or that. Why? Because there is a separation of the work in the company. The shareholders have their own responsibilities. At the same time, management has their own responsibilities, and they have to protect the capital and grow the company. That is the idea. So if you will see the provisions, there is a general prohibition of reduction of share capital. You cannot reduce the share capital, whenever you like. There is a provision, there is a procedure given for that. Similarly, there is a concept of solvency of companies. So solvency of companies we had discussed in our previous session. If you look at the session, you will be able to understand that every company must have a adequate working capital, and they cannot, default on payment. So whenever they have taken a loan, they should be paying installments on time. If they are not able to solve that or pay the installments in time, they will be actually committing a mistake, and that may lead to insolvency of the company. And nowadays, after coming up of the insolvency and bankruptcy code, this issue has become more prominent, right? So concept of solvency of companies is very important. Their financial health should be sound enough to discharge all their debts. If they are not able to discharge their debts, there is an imbalance between equity and debt. Then in those situations, the company, may become insolvent. Similarly, there are provisions with reference to buyback of shares. So companies cannot, buy back their shares or from the market, because there is a minimum public requirement. If you see Securities Contract Regulation Act, it says 25% of the shareholding must be public if it is a public company, and that has to be maintained. So you cannot just withdraw that money from the public, that securities from the public by paying it. So this is something which is again guarded. So if you will see, there is also a new section, that is section 48, which talks about variation of shareholders' rights. So if the existing shareholders' rights have been varied, and variation of shareholders' right can happen by multiple ways. Like, for example, you issue additional securities, then automatically the existing securities will go down their share. So these are the mechanisms by which you are varying the shareholders' right. And whenever there is a shareholders' right variation, you need to have proper approvals, and mechanisms are provided. So these are the points which in the company law focuses on maintenance of capital, and accordingly raising of capital is also very, very important. So distribution of dividends and utilization of funds from the share premium account, these are all guarded very, very carefully, and this ensures a financial discipline. So maintaining the financial stability and solvency of the company is the objective of these provisions, specifically the prospectus and all raising of capital provisions and maintenance of capital provisions. I hope this philosophical background is clear to you. This is very essential, for you to understand why we are talking so much about prospectus and allotment of securities, why we need to follow these procedures, why this much of a disclosure is there. Because you want to keep everything fair and transparent. You want the corporate governance of the company to work in a proper way. And you just don't want any financial bungling happening in the company. And that is why you have all these provisions in place. Uh, Before I proceed, any questions till this point? So there is a creditors and stakeholders basically rely upon this capital, and hence this capital needs to be looked at. So anyone who is dealing with a company is looking at the balance sheet, is looking at the financial health of the company, and you people will be doing due diligence of the companies, and you will be certifying that okay, fine, the financial health of this company is good or bad. And as valuers, registered valuers, these are the task which is done to show confidence in the company's potential for future contract and working with the company in a proper way. So I hope this is clear to you. I would like to ask any questions till this point if you have any one of you. Any questions or any clarification specifically you have. Okay, so how many of you have attended the sessions which I took on this topic? I think all of you have attended. I don't think all of you have attended because I see a few new names in the list. If you have not, I think you will be having that particular. Good morning, Amal. So you will be having that recording already with your portal. So you can go through that as well in quite detail. Uh, but if you have any specific questions, you can put it now. I will be happy to answer that. Because idea and objective of this LVRC is basically to clarify your doubts. I don't have to take a class again because I've already taken the class. So idea is to address your questions. On this concept of raising and maintenance of capital, any point which you would like to make, any one of you? IT team, please enable their mic in case they want to speak. Yeah. Any point or question? Okay. It seems that you are good. There are no questions. Let us move ahead. And so there are various models of raising capital. So share capital can be raised by the company in a number of ways. One of the ways is private placement. So private placement is a situation where you go to the friends, relatives, promoters, directors, and if you can do that if you are authorized by a special resolution. This is Section 23 of the Companies Act. And in case of public company, and Section 23 to be in case of private company. prospectus. I hope you people are all enjoying it. Let us move further. And I was discussing about the, types basically. So various modes of raising capital. And let us, go ahead with that particular part. Uh, if you can, enable the sharing of the screen, please. Yes, then Mozi, you have any question, you can ask me. You raised your hand. It was by mistake or you wanted to ask question? Please enable the slide sharing. Okay, in the meantime, I get permission to share the slides. Let me take you to the point which I was discussing with you. So we were talking about various modes of raising capital, right? So, and there are basically, if you look at three primary modes of raising capital, which is discussed in section 23 of the Companies Act, and it is 23(1) A, B, and C. The first one talks about private placement, and then we have public issue, and then rights issue. So, private placement is a situation where you are reaching out to the people, that is, relatives, friends, promoters, directors, and these number do not increase beyond 200. This is what is the requirement. If it goes beyond 200, then that issue becomes a public issue. This is the difference between private placement and public issue very clearly. So if you are going to public, so public issue is defined as inviting public to contribute to the share capital. The question arises here that who is this public? So the definition of public under the Companies Act is not specifically given, but if you go beyond the number that is 200, then it becomes a public issue. Previously, under the Companies Act 1956, this number used to be 50. And then there is a third type of raising capital that is called rights issue. And this is a situation where you are asking the existing members to take new shares in proportion to their existing shareholding, in respect of a public company, also in respect of a private company. This is called rights issue. So if the existing shareholders are told, fine, you take, capital, then that is called rights issue. So rights issue, public issue, and private placement. These are the three modes of raising capital. IT team, can you enable please the share button? Okay, so I was discussing about this slide. So private placement, public issue, and rights issue. These are the three primary issues which you are able to see where you can go ahead with raising the capital. Now let us look at the other types of also share capital can be issued in other ways as well, other than the three primary issues which we have seen. That is, it can be issued as sweat equity. So this is a situation where you issue shares to the employees, directors, promoters in lieu of their service to the organization, and that is covered under section 54. This is not part of our syllabus which we are discussing today, but just for your information, these are the points. ESOPs, these are again issued to the employees on passing of special resolution. Then we are having bonus shares which can be issued. Then we are having conversion of shares into fully or partly paid up shares. So these are some of the mechanisms by which you can issue the share capital. There is also one important one is global depository receipt. So if you can also issue a global depository receipt in a foreign country, and this section is covered in section 41 of the Companies Act, and that is part of this chapter. So you need to read 41 and understand the global depository receipt. So global depository receipt is a situation where an Indian company is going outside and raising the capital. That is, global depository receipt. So if structure wise, if you look at it, issue of securities, either it can be to the public or by a public company or a private company. In a public company, it can be by way of a public offer, or it can be by way of a private placement, or by way of a rights issue. So these are the four major modes. And then there is a bonus issue, which also you can include there the number of other types of issues like sweat equity, ESOP, etc., etc. They are all other types can be included there. But primarily three types: public offer, private placement, and rights issue. In a public offer, you can go ahead with initial public offering, that is called IPO, further public offer, that is wherein you can wherein you are going for the second time for an IPO, that is for an public raising of capital, that is called FPO, and then OFS optionally. This is how you go ahead with different types of public offer. We will go into the details of them one by one. So section 23 explain these types, and offer for sale. OFS is offer for sale of securities to public by an existing shareholders through the issue of prospectus. Now, section 23 defines this, and we have already discussed this, so I will not repeat that again. A private company may issue securities. Similarly, you can see section 23 talks about that. This is what we were discussing. So now let's reflect on this particular question. What do you think is the answer? Under the Securities Contract Regulation Act, Securities Contract Regulation Act is the legislation which defines securities, and it also establishes the stock exchanges. So this is the utility of Securities Contract Regulation Act, very important as far as raising of capital is concerned, prospectus is concerned. So the question is, under Securities Contract Regulation Act, which of the following is not included within the definition of securities? What do you think? I have got one response from Rajneesh, that is D. Any one of you? Any remaining one of you? Okay, so I got two responses, three responses. Very nice. So answer is D, and you can see unit-linked insurance policies are not included into the definition of securities. And the definition of securities you can find in section 2H of the Act, which defines securities to include various terms are used, right? Shares, stocks, bonds, debentures, derivatives. Units of mutual fund are included here. Collective investment schemes are included. Government securities are included, and rights or interest in securities are included. However, the explanation specifically clarifies that unit-linked insurance policies issued by insurers are not treated as securities specifically. Okay. So this is the point. So if you look at the term securities, Companies Act defines the securities in Section 2, Subclause 81, and it refers back to 2H of Securities Contract Regulation Act, and that is how we have to go back to Securities Contract Regulation Act to find out the meaning of securities. So this is the definition of securities. As you can see, a number of items are listed there. That includes government securities, rights or interest of securities, and collective investment scheme. All those things are mentioned. So you can go through them one. This is another question. What do you think is the response? XYZ Limited, an Indian company, intends to raise capital from investors outside India states that are traded on US stock exchange. The instruments issued to investors in this case are known as. Okay, so all of you are answering GDR, that is Global Depository Receipts. I think you missed a bit. Okay, so it is American Depository Receipts because it is issued in United States, right? So United States, there is a specific, we call it ADR, that is American Deposit Receipts. So when a non-US company raises funds, it is Global Depository Receipts. And if it is US, then it is American Depository Receipts. So because this is getting regulated by the US Securities Exchange Commission specifically. Okay. So if you have overseas securities market, so this concept of American depository receipts, Indian depository receipts, and global depository receipts are for the overseas securities market. And Section 23 specifically says that such class of companies may issue such class of securities for the purposes of listing or permitted stock exchanges in foreign jurisdictions. So that is permitted. So the central government may, by notification, exempt any class of public companies from provisions of this particular chapter by House of the Parliament. So you just understand here that issue of capital outside is also governed by the FEMA regulations. So there has to be clear guidelines which is given by RBI under the FEMA. So they need to also comply with the FEMA regulations. There are at this particular stage, I would also like to highlight that Section 89 and 90 of the Companies Act provide for declaration of beneficial interest if any share. So this is basically to prevent, and this is also related to impersonation of shares. And likely I will touch this 89 and 90 when I teach you that. So then you will be able to relate. I will just park it right now. 89 and 90. We'll talk about it in a while. Now, this is the question. What do you see? Yes, Nitu, all these documents is already uploaded on the portal if you see, but this LVRC session also we will upload it. These slides you will get it. Yeah. Okay, so this question is summary of modes of issue of securities. So, okay, I think it is saying which of the following modes of securities permitted in both public and private companies. Yeah, right. So, Stenmosi, Barna, Gayatri, Maithili, and I think Rajneesh. You are right that, and Amal and Mridula. You have to again review it. So please review this chart. This tells you. So you can see here, in case of public company, IPO, that is public offer, can only be issued by public company, no private company. Okay. So IPO, FPO, and offer for sale, these are the three mechanisms only meant for public company. Private placement is a situation which you can go for both the public and private companies. Similarly, rights issue and bonus issue for both the companies. Okay. And compliance with SEBI rules and regulations for public company, it is must for a listed company of a company proposed to be listed. So any company which wants to, trade its shares on stock exchanges have to be complying with SEBI rules and regulations. Whereas in case of private company, there is no requirement. Okay. So this is how you should remember and keep it in mind. Any question till this point or any doubt? Any one of you? I hope you got the perspective. So a public company can also go for a private placement. There is no need that every time they should go to a public for raising the money. They can take money from specific group of people or banks, maybe institutional investors. Okay. This is the question. Under the provisions of Companies Act, which of the following matters related to a listed company is administered by the Securities and Exchange Board of India? Okay. I've got two responses. Okay. So under section 24 of the Companies Act, SEBI administers provisions relating to issue and transfer of securities and non-payment of dividend for listed companies, right? So it is basically both A and B. Section 24 of the Securities Exchange Board of India regulates the issue and transfer of securities, right? So if you see, it talks about issue and transfer of securities and non-payment of dividend by listed companies, which intended to get securities listed on recognized stock exchanges, right? And central in any other case, the things are administered by the central government. So for removal of doubts, power relating to all other matters relating to prospectus, return of allotment, etc., are exercised by the central government, the tribunal or registrar, as the case may be. So these are the two matters where SEBI gets the power under the section 24 and read with section 127 of the Companies Act. SEBI's power. So you can see SEBI is now brought into picture. So SEBI has got powers under section 24 subclause 2. So the SEBI is having power in respect of the provisions specified in subclause 1 of 458, and they exercise powers like a securities regulator. So you can see the government can delegate certain powers to different regulatory body, and SEBI is one of them. And with reference to the listed companies, SEBI has got all the powers. So they take care of the allotment, prospectus, all those particular things. There is a detailed regulation by SEBI which takes care of this. Okay, this question, can you reflect? ABC Limited, a public company, plans to raise funds by issuing securities to the public in 3 different tranches within a period of 1 year. Instead of issuing a separate prospectus for each tranche, the company files a single prospectus with the registrar before the first issue. Under the Companies Act, the prospectus filed by the company in this case is known as what kind of a prospectus? Let us see. Okay. Yes, I have got only 3 responses. Yes, so we have got the responses. It is saying shelf prospectus, and you all are right. Many congratulations. So answer is shelf prospectus. So shelf prospectus, as per section 31, is allow certain companies to issue securities in multiple tranches during the specified period without issuing a fresh prospectus each time, subject to a filing an information memorandum before each subsequent offers. So this is basically done by financial companies which has got the objective of raising of capital. So they utilize this shelf prospectus. So this is a very important prospectus. So you just pick up that prospectus from the shelf and then issue the memorandum, information memorandum, and raise the capital. So prospectus, what is a prospectus? Prospectus is defined, and if you will find the definition, it means, so you recollect my discussion on means and includes, right? So it has got both extensive and expansive definition, right? So prospectus means any document described or issued as a prospectus. So this is it is irrespective of the terminology which is used. So any document which is described or issued as a prospectus will be a prospectus, and it includes shelf prospectus, red herring prospectus, and any notice, circular, advertisement, or document inviting offer from the public is a prospectus. So this is the definition of prospectus. And section 2, subclause 70 defines prospectus. And this is the definition which you saw in the chart below. So I hope this is clear to you people. So what is necessary is not the name prospectus on the top of it. It may be written something, but if it is described and issued as a prospectus, then that will be referred to as prospectus. So you can see this is an example of a prospectus, or you can say abridged in a prospectus. And you can see here how this is Edelweiss Financial Services Limited, an example of a prospectus. This I have already shown you before. This is something which is talking about listing. And these are the different intermediaries who manage it, like lead managers, debenture trustees, registrar to an issue, statutory auditor. This I have explained quite in detail during my classes, so I will not go into the much of these details. This question you can try to solve. XYZ Limited files a prospectus with the registrar before making a public issue of shares. However, the prospectus does not specify the final price of the shares of the exact number of shares to be offered. These details are to be determined later based on investor response. Under the Companies Act, such a prospectus is called what? Okay, very good. So you people are all aware it is called red herring prospectus, and red herring prospectus is defined under section 32, and it says red herring prospectus is a prospectus that does not include complete particulars of the price or the quantum of securities offered, and these details are finalized later before the issue closes. So red herring is the word which comes from this fish, but ultimately it means that you are putting people at guard that yes, it is not finalized thing and we will be finalizing later. That is why this word red herring is utilized. So you will generally, when you see this red herring prospectus, it will be like this in red. So they are highlighted very clearly on red, and you can see the dots for fresh issue size. There are dots written there. So these dots indicate that these are not yet finalized. So offer size is not finalized. The final price is not finalized. How much money will be raised is not finalized. So this is the red herring prospectus. Yeah. Are you having any comment? Okay. Right. Next. Read this particular question. A promoter of XYZ Limited acquires a large number of shares from the company and immediately offers those shares to the public through a document inviting public subscription. The promoter argues that the document is merely an offer for sale and therefore the disclosure requirements applicable to a prospectus does not apply. In light of the provisions of the Companies Act, which of the following statements is correct? Okay, I've got two responses. Gayatri says B, Khushi says B. Yeah. The remaining of you? Yeah, Tenmozi B, right? So, good Dikshita B, Maithili says A. Why do you say A, Maithili? The answer is B, the document will be treated as a deemed prospectus and must comply with the prospectus and disclosure requirements. So if you refer to Section 25 of the Companies Act, it says when securities are first allotted to an intermediary and then offered for sale to the public, the document offering such securities is treated as a deemed prospectus. This prevents companies or promoters from bypassing the disclosure requirement by routing the issue through intermediaries, right? So this is the deemed prospectus. So there is also something which is called abridged prospectus. So you can see abridged prospectus. This is of Vishal Megamart. So Section 2, Subclause 1 of the Companies Act defines an abridged prospectus, and this is basically a memorandum containing such salient features of a prospectus as may be specified by the SEBI and making regulations. Generally, you will find the uh, applications which are given to the public for IPOs, there will be accompanied by abridged prospectus. This is not the complete prospectus, but it contains major details of a prospectus, and hence it is called abridged prospectus. Abridged means shorter form. So these are the shorter form prospectus. So Section 25 of the Companies Act defines document containing offer of securities for sale to be deemed prospectus. Why deemed prospectus provision is there? Because many a times the companies would be trying to short circuit the regulations or provisions by not complying with it, or just saying that this is not a prospectus, but still in law, to incur liability, to bring liability on the companies, these documents would be referred to as deemed prospectus. So the liability will not go away. So a company cannot avoid prospectus disclosure requirements by routing securities through intermediaries before offering them to the public. So whenever a company allots or agrees to allot any securities with a view that those securities will be offered to sale in public, any document by which the offer is made shall be deemed to a prospectus. So I can give you an example. So what is the maximum limit for a private placement? Maximum limit of a private placement in terms of numbers? 200. Good. Maithili, so thank you for this input. If you see, so what is this deemed prospectus saying? It is saying basically that, okay, fine. You thought that, okay, fine, you will give it to 200 people. And these 200 people further sell it to more 1,000 people. Then that is public issue, right? So this will be not a private placement. This will be a prospectus which you have issued. And that will be considered to be a prospectus. This is what Section 25 is trying to tell you. So even if you are giving only to, say, for example, 190 people, you offered these shares, and these 190 people further offer it to all other people, and that is the objective, then it is basically, avoiding prospectus disclosures. And that is why there is a concept of deemed prospectus. I hope you have got the concept of deemed prospectus. So all enactments and rule of law containing provisions pertaining to prospectus matters to be stated. Liability, all these things have to be covered here. So in terms of deemed prospectus, there is a case law, SEBI versus Kunam Kulam paper limbs. So it says where a rights issue is made to existing members with a right to renounce in favor of others, if the number of such exceeds 50. So this is a 2013, this is a prior case. So now it has become 200. It also becomes a deemed prospectus. So please read this 50 as 200. Wherever you see old documents where the number is 50, you have to read it as 200. So the securities are offered with public within 6 months of allotment. And these are the two conditions which has to be met, where the full consideration has not been received by the company at the end date of the offer to the public. It means in case of any of the above two conditions met, then issuing document shall be deemed to be a prospectus. Right? Any question on deemed prospectus? Any one of you? Or any submission or a point you want to make? Yes. Prospectus, Kushi, it is not necessary that it is valid only for 3 months. We saw the shelf prospectus valid for whole year. The validity period of a prospectus is written in the prospectus. You have to say that till what time this is valid. What section 25 is using the word 6 months for a reason that securities are, this is for deemed prospectus provision. Okay. So let us look at the requirement of in case of deemed prospectus. So we can see in case of deemed prospectus, there is a requirement that a statement of net amount received or to be received as consideration for securities or offer has to be provided. A time and place at which the underlying contract for allotment may be inspected, that has to be provided. The person making the offer were named in the prospectus as directors of the company, and signing of deemed prospectus on behalf of the company has to be provided. So this is the requirement in case of deemed prospectus, and there has to be two directors who will be signing this. Uh, is it clear to you people, deemed prospectus, all of you? Remember these three conditions for deemed prospectus, right? So whenever a deemed prospectus is there, you need to keep the document for inspection. First, you have to two people must sign as directors, and you have to mention the net amount received or to be received under this arrangement. Now, in our classes, we also discussed this case, Sahara, India Real Estate versus SEBI, and a very important case from the perspective of prospectus and issue of prospectus. So this was a case where two Sahara companies issued optionally fully convertible debentures. And I discussed this as a case study. So here the question was whether the companies claimed it was a private placement to friends, associates, and workers. Funds raised were exceeding 24,000 crores from about 3 crore investors. So this is a classic case of deemed prospectus if you look at it. So legal question was whether the OFCD issued was a private placement or a public issue requiring compliance with securities regulation. So what is your opinion? Was it a public issue or a private placement? Yes, public issue. Okay. And at that point in time, this clarity, there were a lot of confusion. So Supreme Court in this case clarified everything, and they clearly said that even if you are intending to, raise a capital with more than 50 at that point in time, 1956 Act was referred in this case, then you have to, state that it is a public issue. So what constitutes an offer to the public? So in this case, Nash versus Lynn, it has said that whenever you are reaching out to a number of subscribers, that will be considered as public. So can you answer this question? ABC Limited, a public company, makes an offer of securities during a financial year to the following persons. The company claims that issue qualifies as a private placement under the Companies Act. What do you say? Is it a private placement or a public offer? The Dikshita says public issue. Gayatri says yes. But what yes, Gayatri? What it is? It is a private or public? Oh, interesting. We have got a number of responses. You can see the offer will still qualify as a private placement because employees under ESOP and QIBs are excluded while calculating the 200% limit, right? So under Section 42 of the Companies Act, a private placement may be made to not more than 200 persons in a financial year, excluding qualified institutional buyers and employees receiving securities under the ESOP scheme. Since only 180 persons fall within the countable category, the issue remains a valid private placement. So it was a bit trick question. I hope you people have got it. So a lot of people answered private placement like Kushi and Gayatri. Some people got tricked by the number of 200, right? So please read the provision. If you read the provision section 42, you will see that there are certain exceptions which are created. Okay. Now we are moving to contents of the prospectus. So section 26 talks about contents of the prospectus, and every prospectus issued by or on behalf of the public company, has to provide for on behalf of the persons or has been engaged or interested in formation of a company shall be dated and signed, and shall state such information and set out such reports on financial information as may be specified by the Securities Exchange Board of India in consultation with central government. So there are certain things which are mentioned in the prospectus. So there has to be a declaration which says that it is complying with the Companies Act, Securities Contract Regulation Act, and Securities Exchange Board of India Act, right? So there are certain situations where prospectus is not required, like for example, in case of rights issue. Or you are giving debentures to the existing people, or there is a shelf prospectus already, then for every issue that you don't require a prospectus, you just require an information memorandum. Reflect on this question. Under the Companies Act, the requirements related to offer of securities to public will not apply in the following cases. Which cases it won't apply? Yes. Good. Thank you for your responses. So the answer would be A, when securities are offered to existing members of the company under a rights issue. So the provisions relating to offer to the public does not apply where securities are issued to existing member of debenture holders under a rights issue, even if they have the right to renounce the offer in favor of another person, right? So this is the answer. Now filing the prospectus with ROC and SEBI. So there is a requirement of filing the prospectus with ROC and Securities Exchange Board of India. And it says that no prospectus shall be issued by or on behalf of the company in relation to intended company unless on the or before the date of its publication. So there has been delivered to the registrar for filing a copy thereof signed by every person who is named therein as a director or proposed director of the company or by his duly authorized attorney. Every prospectus issued under subsection 1 shall, on the face of it, state that a copy has been delivered for filing to the registrar, and then specify the documents required by this section to be attached. The registrar shall not register a prospectus unless the requirement of this section are fulfilled. So registrar ensures that all compliances are fulfilled and then only it registers. There is a section on statement of expert, and I was looking at one of your years in which this question was asked on this section 26.5 on statement of an expert. So whenever you want to include a statement of an expert, like say, for example, it is a oil rigging company and you want to establish your credential in the prospectus by an oil expert statement, then you have to, the statement which has been made is made by an expert. If you are claiming it, then you need to have a written consent of that person making the prospectus, and you should be sure that that consent is not withdrawn before the delivery of the copy of the prospectus to the registrar for filing, right? So this is basically authenticated statement. So if you are taking statement of an expert, then that has to be valid. Example of experts could be chartered accountants who are providing audit or valuation report. It can be engineer who are giving technical feasibility report. I just gave you an example of oil expert. Legal expert who is giving opinion on a title of a property. So these are the different types of experts. Now, if you don't comply with any of the provisions of prospectus, there is a penalty, and this penalty is now, which not less than 50,000 rupees, and which may extend to 3 lakh rupees. If you see this provision, there is a striking off of punishment of imprisonment. So, in view of ease of doing business under the Jan Vishwas scheme, the laws have been decriminalized. So the criminal part of this penalty for contravention has been removed. If you see that previously this offense was punishable with imprisonment for a term of exceeding, 3 may extend to 3 years. So it was a cognizable offense. So this has been now removed. Validity of the prospectus. No prospectus shall be valid if it is issued more than 90 days after the date on which a copy thereof is delivered to the registrar under section 4. So this is the point which you were asking, Khushi, right? So prospectus is valid for 3 months. You were saying it is not 3 months, it is 90 days. So you have to be specific. So no prospectus shall be valid if it is issued more than 90 days after the date on which a copy thereof is delivered to the registrar. So it is very important. The date of issue is important here for many reasons. And if 90 days have expired after filing of the prospectus, then you have to send a fresh copy of the prospectus to the registrar to avoid any penalties imposed under section 26(9). So I hope this is clear to you people, validity of the prospectus. Now, if you see, I told you that there are companies prospectus and allotment of securities rules 2014. So the share capital and debentures companies prospectus and allotment rules gives the details about the issuance of prospectus and different other dimensions. So information which has to be stated in the prospectus is mentioned, reports to be set out in the prospectus is mentioned, and other matters and reports to be stated in the prospectus has been talked about here in these rules. So rule number 3, 4, and 5 are important. You can just brush it up. It will actually help you, write answers in depth. So if a question has come up, you can look at these rules. If you mention these rules, your answer becomes more weightage. So refer to that. Period for which the information to be provided in certain cases, that is rule 6. So what is the answer to this? Any idea? Recap questions. These are recap questions. Under section 25 of the Companies Act, a document offering securities for sale of public is treated as Okay. So you people are all saying deemed prospectus. Second, according to section 25(2), an allotment of securities is presumed to be made in the view of offering them to the public if the securities are offered for sale within 6 months of allotment. Okay. Then under section 25(2), a document will be deemed to be a prospectus if at the time of offering of securities to the public, yes. So answer is B. That is, full consideration for the securities has not been received by the company. Fourth, the concept of document deemed to be prospectus is intended to prevent evasion of prospectus disclosure requirements. Right? Okay. Now, in relation to prospectus, the SEBI regulations are also important. So SEBI has come up with issue of capital and disclosure requirements, regulations of 2018. That is also called the ICDR regulations. So part 6 of disclosure in the filing of offer documents, disclosure in the draft offer documents and offer document. Here you will find that the draft offer document and offer document shall contain all material disclosures. So it is referring to part A of Schedule 6. There is a disclosure which is provided for. So see Schedule 6, which talks about disclosure in offer document, a breach prospectus, and a letter of offer. And there are details mentioned. So all listed companies which are going ahead with these, they have to comply with ICDR regulations. And if you see the ICDR regulations, in fact, under section with reference to section 24 of the Companies Act, they are making specific requirements, making specific points that you have to see the disclosures which are mentioned in the ICDR regulations. So which are these particular disclosures? There is also a term average prospectus, which is defined. We have already talked about it. So the question now here is, is there a difference between prospectus and offer document? So section 270 of the Companies Act defines prospectus, and it says any document described or issued as prospectus and includes a red herring prospectus and shelf prospectus. But what is offer document? So if you see here, this is how the prospectus is defined. ICDR regulations defines offer document, and it defines it to say that it includes red herring prospectus, prospectus or shelf prospectus as applicable referred to under the Companies Act in case of public issue and a letter of offer in case of rights issue. So offer document is basically the prospectus if you link it with the ICDR regulations. So SEBI refers prospectus as offer document. So, and in Companies Act, it is referred to as prospectus. So the sell prospectus, red herring prospectus, these are all offer documents because you are offering the shares for sale to the public. Section 25 talks about deemed prospectus. This we have already discussed, so I will not touch upon that. This is a Sahara India case, detailed about it, but I don't want to go into the much details of it. Just have a look at it briefly. If you want to, disclosure in and filing of the offer documents, disclosure in the draft of offer documents. This I have already talked about. So this is a prospectus. We had already discussed about this. This is a prospectus, and you can see the major points here. And as you can see, it is not a red herring prospectus. It is a prospectus, and you can see the first size of the issue is clearly written. Size for offer of sale is written. Total offer size is also written. Everything is clear. So this is a prospectus. If you see, these are the people who are involved there. So under the ICDR regulations, if you look at the table of contents of a prospectus, you will find that it mentions some major items. So it starts with general provision, where you are looking at the forward-looking statements, currency presentation, etc. Section 2 talks about the So we were at the point of understanding the ICDR regulations and its, different perspectives. So if uh, you have gone through that, you will understand that it talks about detailed disclosure. All types of disclosure are mentioned. Now we have moving to section 27, which talks about variation in terms of the contract. So IT team, kindly enable the share button, please. Okay, in the meantime, the share button gets enabled. I was discussing about section 27, and that talks about the variation in terms of contract. And if we see section 27 clearly says that once you have issued the prospectus and you want to change the terms of the prospectus which you have issued, then you need to inform again. So it says company shall not at any time vary the terms of the contract referred to in the prospectus or objects for which the prospectus was issued. And so whatever details you are giving in the prospectus has to be further notified as per Rule 7 in the English newspaper, vernacular newspaper. And you have to, if there are any dissenting shareholders, you have to, who have not agreed to the proposal to vary the terms of the contract, then yeah, they have to be given an exit offer by the promoters. So it is very important because once you are raising capital, you should know for what you are raising capital, and people should be made aware about that. So you cannot, take money for X item and spend it in Y item, right? So this is very clearly mentioned in section 27, which talks about variation in terms of the contract or objects in a prospectus. Previously, this problem was there where, people would raise money for some purpose and utilize it for some other purpose. And it may be a risky venture. People don't want to spend there. Or say, for example, a company raises money saying that they are sustainability company. They would be initiating all sustainability activities, and they are not doing sustainability activities. Otherwise, they are doing something else. So it will be actually, defrauding the investors, because investors have a particular set of mind to invest into a company, and they cannot be taken for ride. This is something which has been talked about in variation in terms of this contract. If you look at the rules under 7, there is a detailed rules which is mentioned, and there is a requirement of a form also. So PAS1 is a form which has to be filled in case of there is a variation or there is a situation. So IT team, are you there? Can you please, enable my sharing? Okay, students, I think we can take a small break here till the time IT team fixes it. Let us take a break of not more than 10 minutes. I think it is already 8:24. We meet at 8:35. Okay? हाँ 8:35 वी मीट. बट मुझे एनेबल कर दीजिए प्लीज, नहीं तो फिर मैं शेयर नहीं कर पाऊंगा स्लाइड. अच्छा अच्छा, ओके, ठीक है. ठीक है, ओके. इन द मीन टाइम प्लीज एनेबल. ओके. वी मीट एट 8:35 नाउ. We are discussing about ABC Limited, which issued a prospectus for raising funds to establish a manufacturing plant. After raising the money, the board decided to use the funds to invest in a technology startup without seeking approval of shareholders. Which of the following is correct? Okay. So yes, answer C is correct because under Section 27(1) of the Companies Act, a company cannot vary the terms of the contract or objects stated in the prospectus unless approved by the shareholders through a special resolution. What about this? Read the question and you can then respond. It is Mr. A, B, and C are major shareholders of XYZ Limited, an unlisted public company. In consultation with the board of directors, they decided to offer a portion of their shareholding to public. A document was issued inviting the public to purchase these shares. Later, some investors alleged that the document contained misleading statements. The shareholders argued that since the shares were being sold by them personally and not issued by the company, the document cannot be treated as a prospectus and company should not be liable. Which of the following statements is correct? Okay. I got responses from two people. They say B. Is it correct? Let us see. Yes, answer is B. That is under Section 28(2). The Companies Act, any document by which an offer of sale of shares to the public is made by certain members is deemed to be a prospectus issued by company, and all provisions relating to contents of a prospectus and liability for misstatements would apply. So now we move on to Section 28, which talks about offer for sale by certain members of a company. So where certain members of a company propose in consultation with the board of directors to offer in accordance with the provisions of any law for the time being in force, whole or part of their holding of shares to public, they may do so in accordance with the such procedure as may be prescribed. So this procedure is prescribed in the rules, prospectus rules. So any document by which the offer of sale of public is made shall be, or for all purposes, be deemed to be a prospectus issued by the company. So whenever there is an offer of sale by the company, that is considered as prospectus, and all situations relating to misstatement and all those things apply to that. So Rule 8 of the prospectus and allotment of securities deals with offer of sale by members. So it must mention the provision relating to minimum subscription, application value, all these provisions which are applicable to prospectus are also applicable to this offer for sale. This is the question. XYZ Limited raised funds through a prospectus to build a logistics park. Later, the board decided to use the funds to invest in a renewable energy venture. The board passed the resolution without shareholder approval. Which statement is correct? Okay, so you are correct. The answer is C. That is Section 27 requirement of a special resolution is there. So whenever you are varying the terms of a offer, then you need to, uh, pass a special resolution. Okay. Section 29 talks about public offer of securities to be in dematerialized form. So, in fact, in my class, I have discussed in detail about dematerialization and explained you that how dematerialization happens, what is the purpose of dematerialization. These are the things which we discussed. So, what is dematerialization? Dematerialization is basically changing the physical shares into electronic form or a fungible form. So now under the regulations, all shares have to be in dematerialized forms, and that becomes easier for transaction, transfer, all those particular provisions. So Section 29 talks about that. So whenever you are going ahead with offer of securities, it has to be in a dematerialized form. So the physical form of certificates have been done away with now. So there is a mechanism for and in mechanism involves depository participants, depository issuer, and client. So the statement, the steps followed for dematerialization works like that. It is a seamless transaction. Nowadays, people don't go into the depth of these transactions because it is now routine. Just like a bank account, you have a demat account where you hold securities. It is linked to the bank account for money transfers. And whenever you purchase a company's share through the depository, the shares get coming to you. There is also the ASBA process by which your account gets blocked whenever you apply for an IPO and all. So these things which we have discussed quite detail. So I am not going into the depth of these again. If you have any question on dematerialization, I would be happy to answer. Any one of you, any question on this particular topic? Is this section specifically, section 29? It's simple section which mentions that the offer of securities shall be in a dematerialized form. Any question you can ask me on section 29. If there is no question, we will proceed. If there are no question, you can mention clear so that I can proceed on this section, section 29, dematerialization of securities. Okay, so now let us move ahead with the section 30, which talks about advertisement of prospectus. So there is a requirement of advertisement of prospectus. As you can see on the right side, this is an advertisement. So where an advertisement of any prospectus of a company is published in any manner, it shall be necessary to specify the following things. The first, contents of its memorandum as regards to the objects, liability of members, and the amount of share capital of the company, the names of signatories of the memorandum, and the number of shares subscribed by them, and also its capital structure. So these are the requirements for the advertisement. Now, answer this question. ABC Limited issued a newspaper advertisement inviting the public to subscribe to its shares. The advertisement described the business prospects of the company, but did not mention the liability of members or the capital structure. Which of the following statement is correct? Okay. Tenmoji says it violates the requirement of section 30. Is it so? Yes, it violates the requirement because there is a requirement which says that liability of the members has to be mentioned in the advertisement. Section 31 talks about shelf prospectus, and we had already talked about that. So this is a prospectus which is, issued for class or class of companies where it is issued at the first stage, and then thereafter it is issued in different tranches. So if you have a look at it, shelf prospectus, a company filing a shelf prospectus is required to file an information memorandum before they go ahead with the next tranche or next issue. And that information memorandum must mention all material facts relating to the new charges created, or maybe changes in the financial position of the company from the first issue to the second issue. or such other changes as may be prescribed. And if you have receiving applications at the allotment with advance payments of subscription before making of such change, then you need to inform all the changes which has happened. And if anyone, if there is a change or variation, and anyone who has made the application before that variation, you should give them a right to withdraw the application and refund the money if they are not agreeing to the changes, right? So this is something which is in line with the variation of contract, which is mentioned in section 27. So this is how it is. So let us have a look at this question. ABC Finance Limited, a company permitted by SEBI regulations to issue a shelf prospectus, filed one with the registrar when making its first public offer. The prospectus mentioned a validity period of 18 months from the date of opening of the first offer. Which one is the correct? Okay, good. So the validity is only 1 year, not 18 months. This is another question. XYZ Infrastructure Limited issued a shelf prospectus and made the first offer of securities 6 months later. During the validity period of shelf prospectus, the company issued another tranche of securities. Is the company required to issue a fresh prospectus? What do you say? Is there a requirement to issue a fresh prospectus? No. Okay. So answer is C. No, a fresh prospectus is not required during the validity of the shelf prospectus, and the validity is 1 year. Right? Let's reflect on this question. RST Limited filed a shelf prospectus and issued securities in January 2025. The validity period mentioned in the prospectus was 1 year. The company issued another tranche in October 2025 and a third tranche in March 2026. Which statement is correct? Okay, very good. So you have got the essence of the shelf prospectus. Let us answer this question as well. PQR Limited filed a shelf prospectus and received application with advance subscription payments. Later, before the second offer, the company disclosed major financial losses through an information memorandum. What is the right applicants have? What rights do the applicants have? Okay. So you can see here the correct answer would be B. That is, they can withdraw their application after being informed of the changes. So you can see this is a shelf prospectus. I just wanted to give you a glance. We already discussed this in detail. So this is the first time you issue a shelf prospectus. And after that, you can see the tranche 1, it is issued. And then tranche 3 is issued like this. So these are different tranches in which the shelf prospectus is issued. Now, section 32 talks about red herring prospectus, and red herring prospectus is defined as a prospectus which does not include complete particulars of quantum of price. And we had discussed the objective of this red herring prospectus. Idea was basically to, see the market potential, explore the price, explore the market so that you can get, more money. So 100% book built issue is a book building happens in case of red herring prospectus. So book building is actually a price discovery method. And in this method, the company doesn't fix a particular price for the shares, but it tries to, give a price range. So in these cases, the underwriter basically builds a book by accepting different orders from different people who want to purchase shares of the company. And that is why you must have heard this term, that the public issue was oversubscribed. So oversubscription means that they were asking for 100 shareholders for maybe 1,000 crores. They received application for 6,000 crores with 600, investors. So now here you have to proportionately allot these shares, and then you can fix your price of the shares at the highest range of the price range which you wanted to raise. So this is how the book built issue works. So say for example there is a price band of 100 to 120. So if your subscription is oversubscribed, you can keep the price at 120 rather than 100. So this is how it works. Okay. So one of the benefit is that it offers better market driven valuation, and popularity of the company also increases by way of this book built issue. But it has also got a risk because it may get undersubscribed and then your issue may fail, and that is the reason we have underwriters in place. So underwriters take care of the remaining shares, and these things has to be disclosed in prospectus very clearly. So section 32 talks about red herring prospectus. This we have already discussed. Section 33 talks about issue of application forms for securities. So it says no form of application for the purchase of any of the securities of a company shall be issued unless such form is accompanied by abridged prospectus. So you have to know that abridged prospectus means a memorandum which contains the salient features of the prospectus, and these salient features are prescribed by SEBI, and every copy of prospectus has to be made available to the person whosoever has made an application before the closing of the subscription list. If the company makes any default in this, then it is liable to a penalty of 50,000 rupees for each default. So if this abridged prospectus will not apply in situations in connection with a bona fide invitation to a person entered into underwriting agreement or in relation to securities which were not offered to public. So if it is a private placement, then there is no requirement of this abridged prospectus. IPO process, I don't want to go into the details of it because this is not part of your syllabus, IPO process. I have already dealt with this issue in detail in my class, so you can go back to the class, and if you want to learn more on this, you can refer it unless you specifically have a question. So ICDR regulations are there, which deals with this whole IPO process. And there are specific requirements which are mentioned. So for rights issue, for further public offer, qualified institutional placement, Indian depository receipts. There is also a specific section for IPO of SMEs. So this is ICDR regulations. You have any questions on this ICDR regulations or this particular point? Any one of you? If you have question, you can ask. Otherwise, you solve this. Use your chat box for asking any question on IPO process or that particular part. If you have any confusion or clarification you need. So this is a question wherein XYZ Limited issued a prospectus inviting the public to subscribe to its shares. The prospectus stated that the company had secured a long-term government contract worth rupees 200 crores. Now, in reality, negotiations were still going on and no contract had been finalized. Our investor subscribed relying on this statement and later suffered losses when the project did not materialize. Which of the following legal consequences is most appropriate? Yes. Okay, so now we are moving into the realm of liability for misstatement in the prospectus. So in this situation, the prospectus stated that company had already secured government contract worth rupees 200 crores, while in reality negotiations were still going on. This statement creates a false impression about material fact, and it is inducing or influencing investment decision, and hence under section 35 of the Companies Act, any person who authorizes the issue of prospectus containing an untrue or misleading statement has to incur civil liability to compensate investors who relied on that statement and suffered the loss. So your correct answer would be B, wherein the directors may incur civil liability for misstatement in the prospectus. let us look at this. A prospectus issued by ABC Limited included a report prepared by an independent expert regarding the value of certain mining assets. The expert had actually withdrawn his consent before the prospectus was issued, but the company still published the statement. Which statement is correct? Okay, so you are correct in a sense. So whenever expert gives a opinion, his consent has to be valid. If he withdraws the consent before the issue of the prospectus, then that is a misstatement if you are still using that expert's input in the prospectus. So answer would be B, where inclusion of expert statement without consent amounts to misstatement in the prospectus. Now, section 34 talks about criminal liability of misstatement in the prospectus. So where a prospectus is issued, circulated, or distributed, and it includes a statement which is untrue or misleading in form or context, then every person who authorizes it shall be liable under section 447. 447 talks about corporate fraud. So, however, whenever there will be a criminal liability, you have to provide a defense also to the person concerned. So you have that defense may also be there. So section 447 provides for punishment for fraud, and without prejudice to any liability, including repayment of any debt under this act or any other law for the time being enforced, any person who is founded to be guilty of fraud involving an amount of less than 10 lakh rupees or 1%. So this is basically 447 talks about punishment of fraud in corporate frauds. And that liability is also there under section 34. So anybody who does publish information in the prospectus which is incorrect may also be tried for criminal conspiracy. Section 447 we have already discussed. So we will not go into the details of this. This is how the declaration is given in prospectus. So, the directors who sign this document are bound by that. So they mention specifically that I take the responsibility or that the contents of this particular prospectus is correct and everything is right, all compliances have been done. And after this declaration, if it is found that they are not correct, then they are having the liability. This is how the statement goes. So you can see here on the no information material to the subject matter of form has been suppressed or concealed. All disclosures in statement has been true, accurate, correct. So this declaration binds as a
अशोक जी इलेक्ट्रिसिटी इशू है। यहाँ पे रोक दीजिए।
And if you see I think you will be able to bear with me. Let me share you the slide. This we were discussing about the criminal liability. Okay, so and whether the companies can be prosecuted for criminal liability. I think we had discussed this point in quite detail in our previous session also. So if you look at one of the important cases which deals with criminal liability is Iridium India Telecom versus Motorola Incorporated. So this was a case where, the Iridium India Telecom filed a criminal complaint against Motorola for cheating and criminal conspiracy. The question before the court was that can the company be prosecuted for 420 or, cheating offenses? And the court said that yes, they can be, and the punishment or criminal intent requirement under the IPC would be taken from the company's board's idea. So that was the key legal issue here. And they came up with the doctrine of attribution or identification. And that is how, this criminal liability of corporations got established in India, specifically through the different other cases like Standard Chartered case. So if you look at the nature of misrepresentation in this case, there was a projected subscriber base, which actually was not there. And then it was considered as, misstatement in the prospectus. So the basic rule of framing the prospectus was laid down by Justice Kindersley in New Brunswick case. And it specifically said that the emphasis of the court was that investor rely entirely on prospectus prepared by the promoters and directors, and it establishes full and fair disclosure requirement in a prospectus. So because this information, there is an information imbalance. So if you look at in a company has all information, but people who are investing in a company doesn't have all the information, and hence they need to have the information. They need to have all the information, and if they don't have the information, how they will invest. And it is the duty of the people who are giving this information that they should give full disclosure. And that is why these two provisions, misstatement in the prospectus, are having both the type of liability. One is a criminal liability, which puts pressure on the directors. They cannot, they have to look twice because it is not only about the money. And then there is also a compensatory or the civil liability, wherein compensation, if somebody has got a loss because of this issue, can be compensated about that loss. Let us reflect on this question. So there is a prospectus of Oceanic Shipping Limited that the company has paid regular dividends to its shareholders for the last 12 years. The statement is factually correct. However, the prospectus does not disclose that during the last 5 years, the company suffered losses and the dividends were paid out of capital reserves rather than trading profits. Investors subscribe to the shares believing the company to be financially sound. Which of the following statements is correct? There is no misstatement, or there is misstatement. What do you think? Okay, there is a misstatement because omission of material facts can make a true statement misleading. Okay, that is what then Mosey says, and it is a correct answer. So even if a statement in a prospectus is technically true, it may still amount to misleading statement if material facts are omitted, right? So in the case of R versus Kyle Sant, this is a famous case. A prospectus was issued stating that the company had regularly paid dividends. Although the statement was true, the court held it fraudulent because it did not disclose that the dividends were paid out of the secret reserves, while the company was actually making losses. This is what exactly happened in Satyam case, if you would recollect, right? So the Satyam scam, the Ramalinga Raju was cooking the books. It was trying to show profits while the company was not doing that profits. It was maintaining that graph, and that was a fraud. So this is about this. So there are defenses available to avoid criminal liability. I think in this, by mistake, the answer is already shown, but you can have a look at the question. It says under proviso relating to criminal liability of misstatement of prospectus in the Companies Act, which of the following is a valid ground of defense available to the accused person? So these are the three important grounds available for anyone against whom a criminal liability is imposed. So say, for example, you are the director of a company and a prosecution comes up against you, you can take three grounds. One, that the statement or omission in the prospectus was immaterial. So you can say that the matter which is being referred to as incorrect or something is immaterial to the decision of the investor. Second, the accused has a reasonable ground to believe that the statements were true. So if you were under the impression or you have a reasonable ground to believe that statement was true, then you can be saved. And last, the accused continued to believe the statement to be true up to the time of the issue of the prospectus. So these are basically, defenses and lawyers would argue these particular points before the court to save the directors. Then there is civil liability. We have already seen section 35 talks about civil liability of in case of prospectus. And this anybody who is acting on the statement made by in a prospectus, then every person or company and every person who is a director or he has authorized himself or is a promoter or has authorized to be issued this prospectus or is an expert, they all shall be liable to penalty under section 35. So they have to pay the compensation to every person who has sustained that particular loss. This is a civil liability. Let us reflect on this. Under the provisions of the Companies Act 2013 related to liability of misstatement of prospectus, which of the following situations will exempt a person from liability? What is your answer? Which of the following do you think will exempt the person from a liability? Okay, Gayatri says C, then Mozi says C. So let us see. Answer is C, that is both A and B. So a person will not be liable for misstatement of a prospectus if he is an expert and he has withdrawn the consent or there is lack of knowledge. So these are the two situations in which they will not be liable. Let us reflect on this. Under the provisions relating to liability of misstatement in a prospectus in the Company Act, a person will not be liable if the prospectus was issued without his knowledge or consent and after becoming aware of it immediately. Which is the answer? Okay, they are saying A. Okay, so the answer is A. That is, person can avoid liability if he proves that the prospectus was issued without his knowledge or consent, and upon becoming aware of its issue, he promptly gave reasonable public notice. Right? Now, let us reflect on this question. Under the provisions relating to liability of misstatement in the prospectus in the Companies Act, a director can avoid liability for a misleading statement made by an expert if. Which of the following situations? If. Yes. If. Okay, the answer is A. Correct. The director will not be liable for a misleading statement attributed to an expert if he proves that the statement in the prospectus was correct and fair representation or copy of the expert report and had reasonable grounds to believe that expert was competent and the expert had given the required consent, right? So this is or has been withdrawn before the issue of registration of prospectus. So this is about the expert opinion, and it is basically the focus is due diligence. So if the expert is due diligent and they are saying that, okay, fine, we have given the consent, but we have withdrawn the consent before the prospectus was issued, they will not be held liable. Section 35, civil liability of misstatement in prospectus. We have already discussed this, so we'll skip that. Okay. So if you see this particular question, this question is basically talking about the section 35, civil liability of misstatement in prospectus. It says under the provisions relating to liability of misstatement of prospectus in the Companies Act, what is the consequence if it is proved that the prospectus was issued with intent or to defraud the applicants? So here you can see the process. What are the consequences? Consequences are mentioned in section 35(3). So it says, notwithstanding anything contained in this section, if it is proved, then they will be personally liable, right? So there has to be a personal liability of these people who have given these statements. Derry versus Peak. This is a case which is a landmark decision in United Kingdom's House of Lords, which defined the boundaries of fraudulent misrepresentation of torts law. So they talked about the misstatement in the prospectus, and there it was considered as deceit. It was considered as deceit. Yeah. And there is another case, Peak versus Gurney. So here in this, Gurney issued a fraudulent prospectus on behalf of the company. No shares were purchased by Peak at that time. And several months afterwards, Peak purchased 2,000 shares of the company from the stock exchange. He bought an action against the director for deceit. Here, the court held that directors were not liable as the shares were not purchased on the basis of prospectus, but he purchased it directly from the stock exchange, not from the prospectus. So, see, there's a difference, right? So, in case of an IPO, you are directly approaching to the people as an offer document. In the stock exchange, people take their own decision after looking at it. If, in fact, you must have heard this statement many a times that market investments are subject to market risks, right? The mutual fund investments are subject to market risks. So if you are purchasing it from secondary market, then these liabilities don't apply. If you are purchasing it from the primary market, then it is kind of an offer document, right? Like a contract, you are offering it and then giving false statement. So that is why these are the two differences. I remember these cases. If the question comes around this, you should be able to answer them along with these details. So what is the damage for deceit? Contract Act also provides for damage for deceit. So if someone is, deceiving you, then there can be an injunction. There can be a, penalty which you can ask for. You can ask for compensation for the loss which has been incurred by you. So if you see the summary of section 34 and 35, there is liability of misstatement in prospectus can happen in two ways, civil and criminal liability. And in case of criminal liability, punishment is under section 447 of the Companies Act. And in civil liability, you have to pay compensation. You have defenses in case of section 34 as well as 35. So these defenses are available to the people against whom the cases are filed. Section 36 talks about punishment of fraudulently inducing persons to invest money. So there may be situations where someone fraudulently induces someone कि नहीं इसमें invest कर ही लो and purchase this particular share. Then that is also there is also a punishment for that under section 447, right? So punishment is there and which is imprisonment up to 5 years. And if it is exceeding 10 lakh rupees or 1% of the turnover, then 10 years and 6 months. It is quite a huge punishment. And if it is a fraud in question involves public interest, then again 10 years. And amount of penalty is 3 times the amount of fraud. So it is a very, strict section, I must say, where any corporate fraud is punishable by these particular penalties. Section 37 talks about action by affected persons. So anyone who is affected by a person or a group of persons by misleading statement, they can file a suit in a court and then claim compensation. So a civil suit, you may be knowing, is something which is under the Code of Civil Procedure. And nowadays we have Commercial Courts Act in which these civil suits are filed. So that is, there may be also a class action suit under section 245 and 246 of the Companies Act. So this was one case which we discussed in our class. I am not repeating it. It is IPO of Yes Bank Limited. You will have a look at it. And then punishment for personation. So many a times what will happen is someone will be personating the other person or a fictitious name, right? So they want to abet someone to, do the investment by way of fictitious name. So that is also liable to be punishment under Section 447. And there can be also disgorgement of gain. Disgorgement means returning back to the person who has been done a wrong. And then there is also a requirement of investor education protection fund money. So this is the website. I will not go into the details of these. These things I have explained in my classes before. So you can go into that. But impersonation has been talked about in Section 38. It says that someone who is acting on somebody else's behalf or trying to cheat someone is taken care of here. Now, Section 39 talks about allotment of securities. So there is a process of allotment of securities, and as per Regulation 45 of SEBI ICDR, the minimum subscription is required is 90%. So if the IPO is issued and minimum subscription is not 90%, then IPO cannot succeed. You have to return the money. And hence, there is a requirement of intermediaries. So you will find that companies get underwriters to underwrite so that their issue, say, for example, even if it is at 85, 5% can be bought by the qualified institutional buyers on a commission. And this fact that you are engaging an underwriter has to be mentioned clearly in the prospectus. So this is allotment of securities. So there cannot be any allotment of securities offered to the public for subscription if unless the minimum subscription is 90% and the sums payable on application of the amount so stated have been paid by the company through check or instrument. Further, if you see the amount payable on application on every security shall not be less than 5% of the nominal value of the security. So if the nominal value of the security is 100 rupees, then minimum 5 rupees should be the application money, and such other percentage of amount as may be specified. So if you will see under Section 47(4) of the SEBI ICDR regulations, there is a requirement of minimum sum payable for application specified is 25% of the issue price. So that is the requirement under ICDR. So this is how it works. So this now consequences of minimum amount not subscribed. If a minimum amount is not subscribed, then issue fails and the money has to be returned. So they have to return that particular money within 15 days. And generally, whenever an IPO is released, there is an escrow account. So the money lies always in the escrow account. And nowadays, in fact, application money is through ASBA. So immediately ASBA will be released and the money will be going into the bank account of the applicant. So return of allotment, this is what I was telling you. So it will go through that. There is a requirement of return of allotment also in PAS 3. So it has to give that information. So this ASBA I was talking about, that is application supported by blocked amount. This I have explained in my previous class. If you don't have any question on this, I think I can skip this. Let us talk about Section 40. So Section 40 talks about securities to be dealt with in the stock exchange. So this is an important section. It says that every company making public offer shall, before making such offer, make an application to one of the recognized stock exchanges. Why you need a stock exchange? Because it is important. Any shareholder who is investing in your company should have the flexibility or liquidity of his assets, right? His investment. So maximum liquidity can happen only in stock exchange, right? So when you are investing, immediately you want to sell that particular shares, stock exchange is the best place to find that particular selling opportunity, and hence that exit opportunity should be provided. So if you see here in this prospectus, it is clearly written listing, right? So the equity shares offered through the red herring prospectus and this prospectus are proposed to be listed on NSE and BSE. Like this, you have to make an application before you go ahead with the issue of prospectus in the stock exchanges. Generally, the people make application in BSE and NSE. So all monies which are received on application from public from subscription of the securities shall be kept in a separate bank account. This I told you, this is an escrow account where money has to be kept. And these are, if you see a prospectus, these are so many banks where account are opened by the company who is going for an IPO. So there is a refund bank, there is a sponsor bank, escrow collection bank, banker to the company, like this. These are different banks. Banker to an offer, banker to an issue. 44 requires any condition purporting to require bind any application of securities to waive compliances of the requirements of this section shall be void. So nobody can enter into an agreement that, okay, fine, section 40, let it be, let us waive the requirement. You cannot waive the requirement. And if there is any offense or someone does not follow the procedure laid down in section 40, there will be a penalty of 5 lakh rupees, which can extend to 50 lakh rupees. And this punishment part has been removed now. So it is only punishable with fine, but not with imprisonment. So criminalization has been removed of this section. So this is how it is. So company may pay commission to any person in connection with subscription of securities. For more, you need to read this prospectus and allotment of securities rules, as well as SEBI LODR on corporate governance. Let us reflect on this particular question. The board of directors of a company decide to pay 5% of the issue price of shares as underwriting commission to the underwriters. However, the article of association of a company permit only 3% of commission. The board of directors further decide to pay the commission out of the proceeds of the share capital. Are the decision taken by the board of directors valid under the Companies Act? Yes. So this is the answer. So under Rule 13, company prospectus, rate of commission paid for this shall not exceed in case of 5%. So the same rule applies. Therefore, the decision of the board of directors to pay 5% commission to underwriter is invalid. Good. So Gayatri, very prompt answer. Good. You have studied this particular topic. So you can see here, this is the rate of commission. So in case of shares, should not exceed 5% of the price at which share is issued. And in case of debentures, it is 2.5%. Section 41 talks about global depository receipts, and it has been defined. Global depository receipts means any instrument in the form of depository receipt by whatever name it is called, and created by a foreign depository outside India and authorized by a company making an issue. So a company can go for global depository receipts also. Like Infosys went for GDR in Luxembourg Stock Exchange. Tata Motors has issued GDR in London Stock Exchange. GAIL has issued it in London Stock Exchange. So these are global depository receipts. Global depository receipts, maybe you can have small short note. Somebody may ask you, so you can give an answer accordingly. Section 42 is an important section which talks about the offer or invitation of subscription of securities for private placement. So private placement is defined in explanation to section 42, and it says means any offer or invitation to subscribe or issue of securities to a select group of persons by a company other than by way of public offer through private placement offer cum application, which satisfies the conditions specified in this section. So a company may, subject to the provisions of this section, make a private placement of securities. A private placement shall be made only to a select group of persons who have been identified by the board. Now, whose number shall not exceed 50 or such higher number as may be prescribed, excluding the qualified institutional buyers and employees. And so there is some exception, but the number shall not exceed more than 50. This 50 you have to read, I think, as 200. Because things have now changed. So it is 200 after the decision of Sahara. So a company making private placement shall issue private placement offer and application in such form. There are forms which are specified for issuance of private placement and shall not carry any right of renunciation. So these are the provisions. But I don't want to go again in the detail of the provisions. There is also a penalty which is prescribed in case of private placement. So I wanted to ask any questions specifically you have on this section 42, that is private placement. I will be happy to answer. I also wanted to show you some questions of the previous years so that you know how it comes. So I will take you to the question. Let me see. So this is a set of questions which is there on your, I think, January 2026. This was a question which was asked. and it is in a problem statement format. So you can see here, this is a question. Amit Prakash Limited was incorporated in so and so, and it was a mobile equipment, and they issued this at par. And the prospectus further revealed that Amit Prakash has applied for listing of shares in the stock exchanges. And now here the question was, examine the disclosures in the above case study, which are the deciding factor in an allotment of shares and consequence of violation, if any, under the provisions of the Companies Act. So it is a 5 marks question, right? The next question was, PRT Limited is an eligible public company, and then audited balance sheet shows so and so. And then here they are talking about calculate the permissible deposits in each category. So this is not related to prospectus. So you saw that there was a question with reference to prospectus for 5 marks. So if you look at the answer of, so this is the question, question number 2. One of the part included the 5 marks question on prospectus. So likewise, these question banks are important. You go just look at this question bank and try to see how the questions are coming. Generally, as I told you before, that questions in the prospectus part and allotment of securities comes as a problem statement. I also wanted to show you another document, which is you must have seen that, but still I will just quickly show it to you. This is with reference to the examiner's comment. So if you see here, this is with reference to the prospectus. They have said that majority of the examinees have provided correct answers to the parts of the questions, barring few examinees. This question seeks to test the examinees on a disclosure required to be made on the face of the prospectus conditions in regards expert statement and date of publication of the prospectus. So most of the examinees answered correctly to the legal position of the response to the defense made by the company to the notice of the registrar for not filing the particulars of the charge created by the company or the property or assets situated outside India. And in second alternate, majority of the examinees were able to provide correct answers, floating charge, but this is not relating to that. The first part relate to the prospectus. So like this document is also a good handy document which can tell you about how the answers have been given by examinees in different examinations, and you can learn from it that what not to commit a mistake while answering the questions. So this is about the prospectus. I would be happy to take any question on any of the aspects if you have any specific questions. You can raise your hand and ask the question. We will enable your mic, and or you can utilize the chat box for your questions. Go ahead. If you have any questions, you can ask me. Or any doubt or specific clarification you want on any of the points. I was referring to this as well. So you can see here. This is with reference to examiner's comment on section 42. So 42, there are most of the challenges. You need to read the 42 in detail. So if you see, this is one of the examiner's comment. I think I'm referring to May 2024 paper. Most of the examinees could not correctly answer the provisions of section 42.2, 42.6, and 42.8 of the Companies Act, read with Rule 14 of the Company's Prospectus and Allotment of Securities Rules, while answering the type of resolution required, maximum number of persons to whom an offer to be made, consequences of non-allotment of shares, and timeline for utilization of funds regarding to the private placement. So this is very important. Okay. So please see that you answer it correctly, read the provisions. This is about one of the questions in examiner's comment. So section 42 is a detailed section. There are about 7, 8 sub clauses. Go through the clauses. And as I told you before, that reading these sections would be really helpful to you in understanding it better and answering technically correct answers in the examination. Are you having any questions? If you don't have any questions, you can now say no, and then we can close the session. If you have any questions, I am here to answer it. So in your responses, I could gauge that you people have understood the concepts broadly. Only a detailed preparation is required. My advice again would be that prepare your own notes, right, on these points. So it becomes easier for you to refer during examination. And there is always a, photographic or muscle memory, which is there when you write things. So to follow that model, it will be useful to you. So, okay, then if you don't have any questions, I think I will call it a day. Have a nice day, all of you. And I am due for one more session with you people on general clauses and interpretation on 19th. So we'll look forward to having a discussion with you on 19th morning, same time, 7 a.m. Thank you for listening to me very patiently, and my apologies in between. The internet snapped 2 times. That was beyond my control. So thank you for being a nice audience. Thanks a lot. Bye bye. Have a nice day. IT team, now you can close the session.